our first event in our first ever Ethics Week here at UNF. So all of you are part of history. So make sure you write this down as the first ever UNF Ethics Week. This week is meant to highlight ethical issues and to facilitate discussions about different ethical topics across campus that we face and in our community more broadly. I'm John Matheson. I'm a professor of philosophy here at UNF and the director of the Florida Blue Center for Ethics. And just a couple announcements before we get started. On your way in, hopefully you picked up a little ticket. That little ticket you can turn in the Philosophy and Religious Studies Department on Monday and get your very own Ethics Week t-shirt. So please get your ticket. There's also a schedule of the events of Ethics Week out there on the table, as well as on the website for the Florida Blue Center for Ethics. So tonight, very pleased to have our event, Trust and Justice, Debating Supreme Court Ethics. This event is sponsored by the UNF Office of Public Policy Events and the Florida Blue Center for Ethics. Just to give a brief idea of our format, we have 3 panelists who will speak to us for about 45 minutes, and then we'll open it up to questions and comments from all of you and have a great discussion that follows. All right, let me just quickly introduce our panelists, and then I will turn it over for them, and we can start our conversation. So let's start from the very end. We have Nick Seabrook. He is professor and chair of political science and public administration here at UNF, and he's been teaching about the Supreme Court since 2010. And in the middle, we have Justin Sorrell. He's a senior associate general counsel member here at UNF since 2020. He's a graduate of William & Mary Law School, and his primary practice area is in labor and employment law. And finally, we have Adrienne Lerner. She's the associate instructor in political science and the director of our pre-law program here at UNF. So let's please welcome our panelists. All right, and Professor Seabrook, I'll turn it over to you.
Okay, well, thank you very much, Dr. Matheson, for the introductions and for talking about this kickoff to UNF's inaugural Ethics Week celebration. Firstly, I want to apologize about the quality of my voice this evening. I've been getting over a little bit of a cold, so if I say anything crazy or controversial this evening, that's the Sudafed talking. If I say anything particularly insightful, that's all me. I am the lone non-attorney on this panel. I'm a professor of political science. My 2 colleagues here are both qualified and practicing lawyers. And I think it's worth starting out tonight's discussion by thinking a little bit about why we're having this conversation. Not only what it is about the Supreme Court as an institution that lends itself to particularly interesting questions of legal and political ethics, but also what it is about this moment that we're in now that has kind of stimulated a lot of conversation, certainly plenty of controversy about the court and about the ethics of some of its members. I think there are a couple of really fundamental tensions when it comes to the Supreme Court's position in our legal, political, and constitutional system, and the court's existence as both a political institution and as a legal and judicial institution. And as a political scientist, and as I said, the only non-attorney on today's panel, I tend to view the Supreme Court as fundamentally a political and policy-making body. It sits at the head of the judicial branch of government. It's the only federal judicial tribunal that is specifically required by Article 3 of the Constitution, and it plays a role as the ultimate arbiter of the meaning of the text of the Constitution itself. And so what this means in practice is that through the operation of the Supremacy Clause and the Judicial Power Clause of the Constitution, in conjunction with one another, give the Supreme Court the power of judicial review. When the court is presented with a case challenging some action taken by another branch of federal or state government, the court gets to pass judgment on whether that action is constitutional or unconstitutional. And if it's the latter, render a decision declaring that action null and void. in essence, striking it down entirely. And this is an extraordinary amount of power to vest in a single, unelected, largely unaccountable group of 9 individuals who serve life terms in office and can only be removed through impeachment. It naturally raises the political stakes of any conversation surrounding the justices and their activities. It also leaves the Supreme Court in the unique position of being both the most powerful legal tribunal in the United States and also the only one without a binding code of legal or judicial ethics. As a political scientist, I also look at some of these recent ethical controversies surrounding the court, and it's hard not to see partisan motivations at work and conclude that sometimes these controversies are often fueled by political disagreements with the court's rulings. However, the fact that the court itself took the extraordinary step in November of 2023 of issuing a self-enforced code of conduct for the justices that was signed by all 9 current members of the bench suggests at the very least that they are concerned with how these controversies may be reflecting negatively on the court as an institution and are engaging with some of the public discussions and conversations that have been had around this. So Adrian and Justin, just to kind of introduce our topic, and as JDs and practicing attorneys, is there anything that this political science perspective misses in this debate about judicial ethics? And what kind of insight does your legal training and experience give you when it comes to thinking about legal and judicial ethics and the Supreme Court more generally?
Oh, ladies first.
Great. I straddle actually an odd line here. I think practicing attorney is probably a compliment for me, and not to insult you because you are actually a practicing attorney these days. I have been a law professor and a professor teaching in political science and law now since 2013. So practice rusty, but a chance to grapple with a training that is very grounded in kind of traditional law and a social science background as well, which meant that I was very frustrated in law school because I too believed that justices were making policy choices, that law was not free from policy, and that in many ways the Supreme Court is kind of an anti-democratic institution that is also fundamental to how our democracy works. Whereas I'm now a bad member of a political science department because I do actually think that some of the highly socialization and professionalization training that we get in law that makes us revere institutions and believe in certain attributes of public trust is also a real driving force to how we conceptualize and how we feel about law. So I am both a bad political scientist, I guess, on this, and a bad practicing, I'll go ahead and put it in quotes, attorney.
Okay, so for me, first of all, none of that's true about Adrian. She's fantastic on all accounts. As a practicing lawyer, the Supreme Court is massively important to me because there's certain things of the law, you can't just read a statute all the time and understand what is meant by it. You need someone to interpret it. And there's room to disagree, but once it goes to the Supreme Court, there's no more legally disagreeing with it, really. You have to follow what they say. And so the Supreme Court being respected is very important as a practicing lawyer because I need their final word to hold up and for them not to flip-flop a lot. I don't want them to mess with my stuff. Like they set the table for what the rules are, and then if they change the rules on me, I have to drastically change the advice that I give and how I guide clients. We have to do a lot of backpedaling on things. And so the goal for me as a practicing lawyer is to have a stable Supreme Court that believes in something called stare decisis, which is this Latin phrase, which basically means once we've said what the rule is, that's the rule and we're not going to change it. We might distinguish a case, but we're not going to fundamentally step backwards from where we were. That used to be really important, and I went to law school based on that. But in recent years, that doesn't really hold up anymore with the Supreme Court, which is one of the problems that we're having. So for example, the right to have an abortion, that was stare decisis. Like for decades, that was what the rule was. And there might be nibbling at the edges, but that core right was established. So when the court steps away from that and changes its mind and says, oh, that was wrongly decided, or we don't believe that anymore, it causes ripple effects that affect me as a practicing lawyer, because now I have to say, oh gosh, I'm pretty sure I know what it means to not discriminate, but if they change the rule on me on this, I've got to go back to the drawing board. So for me, I have a strong interest in an ethical, stable Supreme Court, because it matters for me as a lawyer on my day-to-day job.
So we can address some of the kind of specific recent ethical controversies as we move through our discussion here. But I want to return to the point that Justin just made for a second, and this idea that judicial ethics is kind of fundamentally intertwined with stability and predictability in the law. And this kind of gets back to the point I made at the beginning, that it's often very hard to disentangle legal disagreements from underlying disagreements about politics and ideology. Now, it's certainly true that the Supreme Court has moved in a conservative ideological direction over the last 10 years or so, most notably since the beginning of the Trump administration and the appointments of Justices Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. And in recent years, we've seen some decisions by the court that have overturned long-standing precedents. The one that most people are probably familiar with is the Dobbs decision, which overturned Roe v. Wade and removed the constitutional right to abortion. There's also been, in the area of administrative law, the powers of the federal government, cases having to do with regulations put in place by presidents and how those are reviewed by the courts that have been pretty transformational as well. But this is really not the only time in our history that we have seen a period where the Supreme Court has made transformational change to the state of the law. If we go back to the 1950s and 1960s and the Warren Court, we saw something similar, but in a very different ideological direction. We saw the court establishing landmark, generally liberal precedents that overturned decades, if not centuries, of law in areas like civil liberties, civil rights, and elsewhere. So is the current controversy about the court, ethics, politics, all of this that's swirling around, is this something that's fundamentally different from those earlier periods when the court made major changes? Or is it simply the case that we're seeing ideological disagreement with the direction that the court's going, and that's been reflected in some of these criticisms that target the justice's personal behavior and things like that?
I'll go first this time, since I made Adrian go first last time. So I think that it is a cycle that we see. So just like Nick was saying, in the 50s we had desegregation happening, and you had a lot of pushback to what the court was doing, people not following instructions. You should know that the Supreme Court has no enforcement arm of its own, so that's kind of the way we're set up constitutionally. So when the Supreme Court says, yes, schools, you must desegregate, they couldn't do anything more than say that. It took the president to bring in troops to help make that happen. So you had a bunch of southern states at that point pushing back and kicking back against what the Supreme Court is saying. So the idea that people disagree with the Supreme Court is not a novel or new thing. What is different now is that we are in the internet age and things spread lightning quick. So when a Supreme Court member's wife hangs a flag upside down in distress right after the January 6th event, that gets, pictures get taken of that gets put on news immediately. Whereas in the 50s, let's just hope that someone from NBC was walking down the street or the local newspaper. So it's different now in that when something goes off kilter with the court, people are much more sensitive to it and much more aware, and people go into the news cycle immediately. And I think that ratchets it up tensions and calls more attention to the changes that are happening.
They're also getting partisan news, right? So we do have more influence in partisan media that has different takes on court opinions or the justices or the goals of the court as well. And so that feeds into that same cycle where you're getting, perhaps fed a narrative about the court or about decisions too. I think it's nothing new to be talking about Supreme Court ethics even. I mean, that goes all the way back to the 20s when we established kind of an ethics mechanism for the federal courts in general. And then the decisions of the Warren Court. I will draw a difference between a court looking at kind of fundamental ill liberties and extending individual liberties as opposed to a court that is reactive to that precedent. And I think there are some constitutional differences that fall along ideological lines that can be drawn there. But I think we see the courts as more partisan now, partially because we see all political actors as in a highly polarized lens and as more partisan and through more partisan news sources as well. So it's easy for us to map onto the behavior and the decisions of Supreme Court justices the same kinds of lens and ways that we look at legislators. But also, I would say that when Congress does less, when people can't get the kind of legal change that they want through legislative systems, there's a history of turning to the courts to try to achieve those same aims. And so as Congress does less and people feel frustrated to be able to achieve legal ends, they turn to the courts and they ask the courts to do more. And that is certainly in some of the is causing some of what we see with the kind of the activity of the court now as well.
So Justin mentioned the controversy that has come to be known as Flaggate. And this, I think, to the extent that there's been sort of a renewed cycle of interest in ethical questions around the Supreme Court, when this happens, it tends to be driven by specific controversies that become headline and newsworthy. And I think there are really two controversies recently surrounding two particular justices that have gained a great deal of media and public attention, and which seem to be driving a lot of the discussions and conversations that have been had. So just to provide a little bit of background for our audience members who may not have been following, but these are specifically the alleged ethical improprieties of two of the justices that make up the court's conservative majority, Justice Samuel Alito and Justice Clarence Thomas. And on the Alito side of things, the flag controversy, as Justin mentioned, references two separate controversies that occurred at the home of Justice Samuel Alito and his wife, Martha Ann Alito. One in early 2021, this was the upside down American flag that was spotted flying outside of their home in Alexandria, Virginia. This has been interpreted by some as being kind of an expression of support of Donald Trump's attempts to overturn the results of the 2020 presidential election. And then later there was a second flag controversy, remarkably enough, involving the Appeal to Heaven flag, which was seen flying outside of the Alito's home in New Jersey. Originally a Revolutionary War symbol, this flag is also allegedly associated with conspiracy theories surrounding the 2020 election. And Justice Alito has maintained that his wife was responsible for the flying of both of these flags and that he was not involved in the decision to fly either of them.
I'll just add in there. I know you're busy students with a lot of homework, but you really owe it to yourself to read the story about Flaggate because the whole setup is incredible. So according to Mrs. Alito, the neighbor had put a sign out that said F Trump, but it had the full bad word, and it was right by a school bus stop. And so she was very frustrated and approached this neighbor and said, "Will you please take down your sign? There are children." In response to which, the neighbor called her the C word. And according to her, her next response was to go and fly the flag upside down. So you should just read this whole story. It's fascinating and well worth your time.
And this kind of gets into the point that you made previously about this being very much kind of a reflection of the social media age, where a dispute between neighbors, one of whom happens to be a Supreme Court justice, kind of blows up into this national story. But this Flaggate controversy led to calls for Justice Alito to recuse himself, so essentially to declare that he had a conflict of interest and to not participate in either of the two Supreme Court cases involving President Trump. The effort to remove him from the ballot in Colorado under a provision in the 14th Amendment, disqualifying individuals who have participated in insurrection from holding offices of the United States. And then subsequently, the case having to do with presidential immunity in the context of the January 6th criminal prosecution. So is this something that under kind of generally accepted standards for recusal of a judge or a justice in a case, is this the sort of thing that you might expect Justice Alito to recuse himself? Or are we kind of pushing the boundaries of what would be considered appearance of impropriety in recusal standards here?
Oh, no, so I'll say that, you know, one of the interesting things, putting on my very, very stale and dusty practitioner's hat for a moment, is that one of the interesting things about watching the Supreme Court that doesn't have to adhere to the ethics code that the rest of the federal judiciary does, is that a federal judge can't put a sign for dog catcher in their yard, right? Like, they have to avoid even nonpartisan election signs. There are very strict rules for state judges as well. And so this kind of stability issue in the law is definitely something that practitioners look for, but practitioners also look to the Supreme Court to be kind of the standard bearers of the judiciary and the court, and for there to be such, such opposing rules as to what a Supreme Court justice can do, the flag that they can fly outside of their house, the potentially political statements that they can make, be that in a flag outside their house or at a conference or a professional society like the Federalist Society or the American Constitution Society, and the very limited scope at which the bar is the appearance of impropriety, not even like impropriety or anything that would violate a rule of ethics, but anything that the public could take to be an improper action or an improper political statement of a judge, you know, that can't happen for federal and state judges. And so to see this very kind of different standard applied is difficult for practitioners that look to the Supreme Court as being judicial leaders as well. As far as recusal goes, you know, one of the interesting things is before they even adopted the Code of Ethics, the Supreme Court actually said, okay, look, we're going to try really hard now to abide by the same recusal rules that the rest of the federal bench is under, and then proceeded to not recuse themselves under that rule. You know, I would say not even necessarily recusal if it was one of the cases like you mentioned. Yes, you most likely see that on the lower benches, but you might even see professional sanction for some of those same actions. And there is the issue here is to also what we demand out of the spouses, children, and family of justices as well.
And just to kind of set a very plain-spoken reason to you for what recusal is and why it matters, you should know that the Supreme Court has 9 justices on it, and that's good to have an odd number so you can break a tie. So recusal is the process by which a justice says, you know what, if I rule on this, I'm going to give the appearance of impropriety or that I'm not serving justice or I'm serving my self-interest, so I'm going to take myself off. That works fine in lower courts because you have other judges that can step in. You can go up a level, you can get a colleague at the same level, no problem. But there's nobody else at the Supreme Court level. So if you have one recuse themselves, you go from 9 to 8. And so with 8, there's a real chance of having a 4-4 deadlock split. These days, most of the important decisions are decided on a 5-4 basis, or 6-3. It used to be 5-4, now it's more 6-3. And it's often on what seems to be ideological grounds or political grounds. So the conservative justices tend to vote as a block, and the liberal justices tend to vote as a block. So if you have a split and you tamper with the numbers and you get 8 or 7 or whatever, if it goes down, there's a real risk that your party's favorite isn't going to be on there. So there's pressure for them to stay in. They've even created something called the rule of necessity that allows them to serve when it otherwise looks like they have a conflict, just because you need all these brains working together. But with a 4-4 split, it would be a catastrophe. So what if this election comes down to something that the Supreme Court has to decide, as it did in 2000 with Bush v. Gore, and instead of a majority decision, you get a 4-4 decision? Well, then there's just still chaos. There was chaos, and the court was supposed to fix it and tell us what the rule is. But now you've got a 4-4 split because someone recused. It's a real problem. And so the people who push for recusal, I agree that, just like Adrian said, the Supreme Court should be your heroes, your baseball star. You have their baseball card growing up, and then all of a sudden you find out they've been doping. Massive disappointment, right? They should live to that high level. But there are real problems on what you do if you do take one of them out on important cases.
And that 4-4 decision goes back to what you said earlier about stare decisis and directing the lower courts and kind of practitioners as well, is that when you get those 4-4 decisions, they don't carry precedent, right? Like majority opinions. And so there is that tendency where you do need the 9 on the Supreme Court, more so than you would in the lower courts. But there probably are ways that we could get creative about maybe having appellate justices step up into those roles as well.
And certainly, debates about whether justices should recuse themselves in cases are nothing new. I remember back in 2004 when Justice Scalia was under pressure to recuse himself in a case that involved then Vice President Dick Cheney, because Scalia had gone on a duck hunting trip with Cheney. This was about 2 years before Dick Cheney accidentally shot a guy on a separate duck hunting trip. You can look that up. But I think the broader point here seems to be that justices are, it seems like, increasingly liable to talk a little bit off the cuff and be fundamentally political people in our highly polarized environment in a way that was not necessarily true in the past. And often, particularly when speaking extemporaneously in interviews or in other settings, seem to be unable to help themselves from making comments that are interpreted as political or which certainly their political opponents can seize upon to frame them as being biased against particular litigants. We saw this, I think, also in the lead up to the 2016 election when Justice Ruth Bader Ginsburg made comments in interviews about then candidate Donald Trump, which were used by supporters of President Trump to argue that she was biased against him. So it's certainly not the case that I think back to the book by I'm trying to remember which one it was, but there was a book about the Supreme Court back in the Burger Court era, and I think it was Justice William O. Douglas who was so insistent on being apolitical that he thought it was unethical for him to vote in presidential elections. That's kind of a far cry from the Supreme Court that we have today. But turning our attention away, perhaps from flags and recusal questions, the other justice on whom there has been some fairly intense attention regarding ethical issues has been, of course, Justice Clarence Thomas. And back in 2023, ProPublica released a series of investigative reports revealing that Clarence Thomas had accepted numerous luxury trips from conservative billionaire and friend Harlan Crow, including private jet flights, international yacht cruises, vacations, stays at luxury resorts. And what was particularly controversial about these revelations is that they had not been included on his annual financial disclosures. Although Thomas later amended his disclosures to include them, there were similar omissions from Justice Alito's disclosures involving trips to Alaska on private jets, also funded by a conservative billionaire. It was also separately reported that Crow had purchased Thomas's mother's home in Savannah, Georgia, where she continues to live, and had paid for the private school tuition of his grandnephew. Thomas has defended himself by claiming that he was advised that personal hospitality from close friends did not need to be reported on the annual financial disclosures. So this is something fundamentally different than from flying a flag in your yard or making a comment during an interview that can be interpreted as being somewhat political. Here we have a justice who is receiving hundreds of thousands of dollars, in excess of $1 million of gifts, of perks, of luxury travel from a conservative billionaire, a friend of his. And it kind of makes you wonder, what is Harlan Crow getting out of this? I mean, maybe Clarence Thomas is just that great a hang that he wants to bring him on his private jet flights and vacations in the Bahamas and elsewhere. But it certainly does raise questions when you have wealthy ideological benefactors who are funneling hundreds of thousands or millions of dollars in perks to Supreme Court justices.
Yeah, it does sort of sound like buying votes if you want to take it to the extreme. And this is another situation where you expect your Supreme Court to hold the same values that lower judges hold. Even practitioners, since Scott's in the room, I'll tell a story about his wife. So I'm friends with Scott, our dean of the Honors College. His wife and I have worked at the same law firm for a minute. And now she's a great lawyer at Mayo. I went out to lunch with her one time and I offered to pay for her. And I was an attorney at a law firm. And she declined because she has the standard that she doesn't want to have anybody paying for her meals. And it was like, I was poor. So it was like a $15 meal. It wasn't anything nice. But she didn't want that appearance of impropriety, even from another attorney buying a meal for another attorney. So if that's the kind of expectation that even we have I'm at the lowest level. Like you can start at the Supreme Court and work way down until you get to me. If that's my expectations and those of others, then we should expect that receiving gifts would look like a bad idea because it looks like you're having your votes tainted in some way or you're casting your vote in a way that is problematic. In fact, I think Fortas, I'm bad with names, so I'll let either of these professors correct me, but Fortas was a Supreme Court justice at one point, and there were allegations that his votes were being bought, and his reaction eventually was to step down. So he did the ultimate recusal where he just got off the court, if I'm remembering this correctly.
Over $20,000.
Over $20,000.
So the equivalent of, I think I ran this number actually, like 160-something thousand today.
Yeah. Mm-hmm. Yeah. So in the past, when people got called out for doing unethical things, the reaction was to step down. Fortas did it. Think of Nixon. He left office. But now you have people who don't step down when they do things that look unethical. Like, there was a big controversy about George Santos and whether he did all the things he claimed to have done, and he didn't step down, so he was forcibly pushed out. So we're in a different political space now where the need to have high ethical standards for leaders is important because there's not always the same societal shame pressure that causes people to leave office that there used to be.
And as I said before, high polarization, we tend to map what we believe about other political actors onto justices, and their actions can bring this on themselves. What this looks like is lobbying, right? So if we think about the trade-offs that we always make when we talk about perhaps enforcing ethics or regulating the court, that's always going to be some kind of balance that we're making between accountability, right, of the justices and transparency. So we want justices to be able to be independent and make independent decisions. We don't want anyone buying their votes. We maybe don't want a system where you direct lobby a Supreme Court justice like you would a congressperson. And we have a lot of rules and ethics rules governing lobbying, and a lot of accountability, transparency rules that govern that process. When this happens, and the only form that can report it is one annual report that a Supreme Court, we have to be trusting of the justice to be filling out completely, that perhaps doesn't match the accountability standards that we have for other branches of government. Again, I've said this is a trade-off. Everywhere that we push Supreme Court justices to be more transparent or more accountable, what we might be losing is judicial independence in that. And so that's really the trade-off that goes into this. If we want to see them as political actors or we expect them to act in certain ethical ways, then how much accountability and transparency do we want out of them? And are we willing to then perhaps have either themselves or even other entities, which could open up a whole constitutional can of worms, enforce standards of governance for them as well?
And in the interest of being fair and balanced and not to dunk exclusively on the conservative side of the court, I will note that Alito and Thomas are not the only justices who have gotten into some hot water for failing to note things that they have received on their financial disclosures. So Justice Sonia Sotomayor initially failed to disclose transportation and lodging that was provided for various law school speaking engagements that she had participated in. She also later amended her disclosures to include those details. And probably my favorite one, Justice Ginsburg was forced to amend her financial disclosure forms in 2017 to include a $4,500 opera costume that she received as a gift. So I wanted to make sure that I noted that. So we've talked a little bit about kind of gifts and perks that justices receive, but it's also been the case in recent years that quite a number of members of the present court have received very, very large sums as advances from publishers for writing books, either memoirs or books on the law or other topics. And this is a major loophole in what is otherwise a fairly restrictive area of regulations when it comes to the extent to which Supreme Court justices as federal employees are allowed to earn outside income. So federal statutes and regulations basically limit federal employees from earning more than around in the area of slightly less than $30,000, I think, in outside income while serving as federal employees. However, there have been several justices, notably Justice Jackson, Justice Kavanaugh, Justice Gorsuch, Justice Barrett, and Justice Sotomayor, who have received hundreds of thousands of dollars, in Justice Sotomayor's case, $3 million in book advances for her memoir or for other books that the justices have written. And this is a pretty gaping loophole, both in the requirements prior to the Code of Conduct, but also in the new Supreme Court Code of Conduct. Book royalties and advances are exempted from the limits on outside income. I would also note that both Justices Sotomayor and Gorsuch failed to recuse themselves from a case that involved their publisher, Penguin Random House, later claiming that it was inadvertent. So it's generally seen, I think, as a good thing that public servants are not also making lucrative money in the private sector on top of their government salaries. To what extent are these massive loopholes for book advances something that provides a loophole to that? And is it concerning that justices are making such enormous figures from publishers?
Okay, so I'll go back to my baseball analogy, right? So these are people you look up to, and you actually do want to hear from them. So some of these justices have incredible stories. Justice Sotomayor has an amazing personal life story, and she is someone that we can and should learn from. And the other justices as well. They have brilliant books on the law, ways to interpret the law. They're helpful for attorneys. We want these people to be sharing their expertise. And under our system, the way you encourage people to share their expertise is financially. Oftentimes, that's how you motivate people. That has to be balanced, though. The need for compensation and incentive probably needs to be balanced with what could be a nefarious book plot, right? So if you have some secret cabal of people who are publishers and they're funneling money through this way, that would be bad. And there should probably be some rules about it. So I don't know, I know students that you're paying an arm and a leg for your books and stuff, and it feels like you're being overcharged. I was there. There are rules about what your professors can assign. Like if they've written the book, there's a person in this room who helps review conflicts of interest, right? So we don't want professors writing a book, making you pay an arm and a leg for it, and then pocketing the cash. The times that I've known about this, a couple of situations, like if someone's writing a book, oftentimes they take the proceeds from their students and they put it into a scholarship fund. So if it doesn't come to their benefit, it goes somewhere else. There's ways to mitigate that. And I feel like if the justices were creative, they could probably find a way to still be incentivized to write, to share their knowledge and life experiences with us who need it and would benefit from it, while also avoiding that appearance of impropriety. That's my personal thing.
My spicy take as a former IP lawyer is that publishers pay famous people big royalties all the time, right? And the more famous you are and the more the publisher wants your book, the more likely to get a high royalty or a high upfront, and then not have to recoup it in sales before you get paid, that you are likely to get. So it's not like the Supreme Court members are getting these deals that like no other famous or notable person is getting. But if we look at them in the context as one of many federal employees, that's very different. If we look at it in the ability of a company to be able to perhaps influence cases that go before the court, and we want some stability in copyright law, which I've given up on, then yeah, those questions are important. But I will say that it's not unusual for people of note to get those very high book advances. And so it's not necessarily out of practice. I also say that some of the ProPublica reporting on Thomas has said that some of the things that prompted some of the donors to do these elaborate vacations and pay for motorhomes and things like this was Thomas speculating very loudly that he didn't make a lot of money as a Supreme Court justice, and he wasn't in it for the money. Something, you know, that they should be compensated better for the job. And so you can also look at maybe some of these private friend donations or some of these corporate, you know, lucrative contracts as ways to keep certain justices in seats, so that they perhaps don't go find more lucrative things to do other than occupying important, perhaps ideological interests on the bench.
They don't get paid what they can make in private practice.
That is true.
They're making like $250,000, $300,000 a year, which is a ton of money. Don't get me wrong, that's a ton of money. But if they were to go and be lawyers, they would easily make more than $1 or $2 million a year. Like they're getting a fraction of their pay. And just like Adrian said, if they were to leave, they could make a lot more money, especially knowing the inside of the court. They could go to a firm and make a ton of money.
And I think that's probably a big part of the explanation as to why it's these two specific justices, Alito and Thomas, who seem to be garnering the lion's share of the attention from conservative billionaires. What do those two justices have in common? They're the two oldest members of the court's conservative bloc. And so given that right now we have a Democratic president in office, keeping them on the Supreme Court, keeping them happy and content in their positions and living at large on private jets and private islands is a pretty good way to ensure that they're going to stick around, at least until the point where those incentives shift. And I wonder if during some future Republican administration, the kinds of messages that Thomas and Alito are getting from the Harlan Crows of the world might be more like, well, think of your legacy. Perhaps it's time to step aside, let a conservative replace you.
Imagine the vacations you could get when you don't have to report them. Yes.
So Shifting gears slightly, I think we've covered a lot of the reasons why Supreme Court ethics are a big topic of conversation recently. But there's been something else that's been occurring at the Supreme Court in recent years that is pretty unusual. And that is leaks of the Supreme Court's internal deliberations. This kind of began famously with the leak of the draft Samuel Alito majority opinion in the Dobbs decision, the case that overturned Roe versus Wade. And that has been followed by a series of kind of bombshell reports from the New York Times, from USA Today, from various different journalistic outlets, all of whom seem to have pretty detailed inside information into the court's internal deliberations in cases that have very, very recently been decided. And just within the court's last term, there was very detailed reporting about the court's internal deliberations in the two cases having to do with former President Trump, the immunity decision and the case having to do with the 14th Amendment and exclusion from the ballot. So what does it tell us about the state of the court that this famously secretive and not prone to leaking institution is suddenly leaking like a sieve?
It tells us that insiders are playing a political game, right? So disclose information that can either keep justice on your side in an opinion, or that can inflame the public and try to put some pressure on the court, perhaps especially on folks like Chief Justice Roberts, who are concerned about his own legacy and the fact that the court bears his name. So you can look at it as political gamesmanship. It's very hard for any of us that have clerked to think about like talking about your judicial office. But I'll have to say that the clerks are getting a lot of scrutiny in some of these leaks. But if you know about the procedures of the Supreme Court, one of the interesting things is that when the Supreme Court goes to conferences every week to kind of discuss the cases that they've heard or the cases that they might take in the future, clerks aren't usually in the room for those deliberations. Now, a justice can go back and talk about what happened. There might occasionally be clerks involved in those discussions, but often they're not. And there are no minutes, there's no video, we have no audio of those. Supreme Court does not have to keep records of their meetings like other branches of government and other public servants do. And so for these leaks to discuss these conferences at length is very unusual. It's unusual for kind of the highly, socialized and professionalized, like ethical values that were taught in law. It's highly unusual for staff that goes to work for judges, but it is, interestingly, incredibly strategically savvy and important if you look at it as kind of political, machinery. And in that, I think we have to just kind of straight look at the political ramifications and the political goals of those leaks, as opposed to being some kind of change in the professional expectations of folks who work judicial staff.
So as an attorney, one thing that we have to honor is this idea of confidentiality, that people come to attorneys for advice. And you need to be able to give them straight advice and talk candidly so that they can make good choices. When it comes to judges, they also need to be able to talk candidly to each other when you have a group of judges making a decision, because they can and do change their minds. You might hear them at oral arguments, taking very pointed arguments and making points to the other side. But as they go and scratch their head in their office, they may be persuaded by what their colleagues say. And so just like Adrian said, when there's a leak, it sort of can anchor you where you feel stuck and you can't change your mind anymore. And that's, in my opinion, that's not good for overall justice, because we want people to come to the right conclusion, not the one that they feel that they're stuck with just because of a leak. So I love transparency. I think sunshine in government is good, but I do think that there is something to be said for confidential deliberative processes that these leaks are undermining, which also hurts the public trust in the Supreme Court?
Well, you mentioned public trust in the Supreme Court, and I think that's a good topic to kind of round out our discussion with before we take questions from the audience. So to whatever extent these criticisms of certain justices or certain practices on the court are being driven by politics, to whatever extent they're being driven by legitimate concerns about ethics and the court, it's certainly clear that it's having an effect on how the American people perceive the US Supreme Court as an institution. So I looked up some polling data from Gallup and other pollsters, and going back to the late 1990s, 80% of Americans reported having either a great deal or a fair amount of trust and confidence in the court as an institution. And that number has been steadily declining since 2000. Today, it stands at 45%. So the last 25 years, public trust and confidence in the court as an institution has slipped from 80% of Americans to 45% of Americans. Over that same period, the court's approval rating has slipped from 60% to 40%. And whereas since the 1990s, substantially more Americans have generally said that the court's ideological leanings were about right, as opposed to saying that they were either too liberal or too conservative. About 40 to 50% of Americans said about right, kind of the Goldilocks zone, and about 20 to 30% would either say that the court was too liberal or too conservative. That changed in 2022, when for the first time, more Americans, 42%, said that the court had become too conservative. That number exceeded the percentage who said that the court's ideology was about right for the first time since Gallup had been asking that question. We also see that as the court has moved in a conservative direction ideologically, partisan gaps in trust and approval of the justices have diverged to an unprecedented extent. So partly, I think this may have been driven by just the broader trends in polarization and ideological divergence in our society. There is some evidence that the Dobbs decision in particular has accelerated this trend in the last couple of years. But it is concerning that the degree to which the American public believe in and trust and have confidence in the court as an institution has been undergoing this precipitous decline. And so the final question then I'll put to my fellow panelist is, what can be done to restore trust and confidence in the Supreme Court as an institution? Are we kind of destined to continue to see our institutions succumb to political polarization, even those that were previously bastions of law and justice? Or is there something that Congress, the American people, the president can do, or the court itself to kind of reverse what we've seen in these polling numbers for the last couple of decades? Yeah, you want me to take a stab at this one first? Great.
I have all the fixes too, so between us, we'll get this right.
So I think that the one of the problems to this is that the way in which most Americans interact with the court, because deliberations are done in conference and in secret for judicial independence, and so that judges can really debate and change their mind. It turns out that the interactions that most Americans have with the court are at their most political times, right? So controversial decisions, they usually drop around the same time, usually in June. They get a lot of press. There's a lot of heat on the court around the end of the term. Nominations and confirmations. So when there's a vacancy and there's a nomination and there's a confirmation process, that process is highly televised, it's highly discussed. There are commercials from interest groups on TV for and against justices trying to get you to call your senators and get involved in the process. Or when there are stories like the ethics stories with Alito and Thomas and the book ethics stories, right, where we see these very kind of politicized interactions with the court. And we don't see the kind of C-SPAN side of the court, right? There's no channel that's covering the boring mechanics of the court day in and day out. And so we can't kind of bore everyone to death with procedure and mechanics, which every lawyer in this room knows there is a lot of. So one might be that we look at the ways in which the court is non-transparent, and we find the ways in which we're not threatening judicial independence, but we push for more transparency so that we can talk about how the court operates in a more knowing way as citizens. The nomination and confirmation process could become something where senators are not just talking to their constituents and running on campaign promises, but maybe actually questioning the nominee in front of them, who most likely won't answer their questions in any meaningful way anyway. Will just pivot and say that they can't speculate on things that might come before the court. So we could have a more meaningful nomination and confirmation process that we could get our head around that still meets the advice and consent clause in the Constitution. But generally, we probably need to be more informed citizens about the court and how it works. We need to have this kind of very comprehensive view of law where we're taking this trust in institutions and professionalization kind of concept of law that we get from law, but this very nice social science, hey, law does not exist in the ether by itself. It's not intuitively discoverable, or else we could put anyone on the Supreme Court and they would all come to the same decisions, right? And so I think that knowing more about the court, the law, and looking at maybe some of the small procedures of how we view the court at its most political times could help. And perhaps maybe telling justices that they're extrajudicial speaking, the things that they do outside of their jobs, their day jobs. Might need to meet a standard that looks a little more like the lower courts as well.
I love what Adrian said. I'll just throw out 3 things. 2 are optimistic, 1 could be practical. So I think that there would be more public trust in the Supreme Court if they were more circumspect and lived up to the standards that other attorneys hold and other judges hold. So if they held themselves out to be more moral exemplars, that would be better. And they would probably gain some measure of public trust by avoiding the controversies that are currently dragging them down. Will that happen? I don't know, but it would be great if it did. Another change that would be nice that might help encourage public trust is if the justices were a little bit more variable in their votes. Right now, it's very easy to predict. If you give me a case, what it's about, I can pretty much predict how the court is going to rule because they're typically on ideological or party lines. That hasn't always been the case. In fact, 20 or 30 years ago, there were judges who would drive people crazy because a Democrat appointed them, but they would vote with the Republicans. That sort of variability would help lessen the look that the Supreme Court is just merely a political tool of whatever party appointed the justices. Do I have a lot of hope that that will happen? No, but it could, and that would be great. And my third is the most practical, which is something that Adrian mentioned, is that the political confirmation process for Supreme Court justices has become highly political. So we had a situation in which there's a lot of disagreement about whether some of the members of the current Supreme Court are legitimately in their seats. And it had to do with replacing a former justice and whether or not that vote would be rushed or not. There's an argument that Merrick Garland should be on the Supreme Court, but he's not because of the way the voting went down in a Republican-held process. That is a bad look, and it further reinforces the political feel of things. So one solution that is wild, but would be to impose term limits on the Supreme Court. So if you had 18-year term limits, there's 9 justices, that means every 2 years someone is falling off the court, which would give every single president 2 appointees to the Supreme Court. And so since you just know that every president is going to get 2, it would take some of the pressure off. Because right now, some presidents get 5 and some get 0. Jimmy Carter appointed 0 in his term. But if you had a more regular process, that would help lessen the politicization of the appointment process and the interviewing process, and also give some more routine turnover to the court. Now, that's not an idea I came up with. It's being floated right now. There would be a fight about the constitutionality of that provision. I would argue that it would be constitutional, but you know who gets to decide it is the Supreme Court. They are very interested in maintaining their own independence. They do not like to be regulated. So I think they've probably reached a brink where they've realized they've got to pull things back. And because of that self-interest, I could see maybe them being willing to accept that kind of regulation because it's not overbearing, but it would give them still a quite nice long term. So that's just my 3 thoughts.
And getting around the appointments, if you give them senior status, like the appellate justices or the appellate judges can take at the end of their careers, should they choose, can fix that recusal problem too. We might be able to have Supreme Court justices recuse more freely if a senior status former justice can step back into a role temporarily, as happens in the lower courts.
I do think part of the problem with the court reform movement is that a lot of the focus tends to be on the least practical and least achievable potential solutions to what's happening with the Supreme Court. If you think back to the 2020 election, there was a lot of discussion about court packing. This came up in the debate between Joe Biden and Donald Trump, whether Joe Biden, should he win the election, would try to add additional seats to the Supreme Court, something that Congress has the power to do should it see fit. Term limits, as Justin mentioned, is another one of these kind of perhaps pie in the sky proposed solutions that have a very limited probability of actually coming true. But I do think that there are things that Congress can do at the margins that can kind of push the Supreme Court towards behaving more like an ethical judicial body and less like a political one. Congress has a lot of control over the Supreme Court's docket. And that docket has been declining. The court has heard fewer and fewer cases as time has gone on, which means that a greater percentage of its rulings are these kinds of hot-button political disputes where we can predict how the justices vote simply by knowing the name of the president who appointed them. Congress could force the justices to decide more cases. They could reduce their discretionary docket and increase the size of their mandatory docket. And if the justices are doing more kind of day-to-day legal work, more day-to-day kind of standard judicial cases as opposed to these high-profile political disputes, maybe that makes the institution into something that's less of a target for these types of partisan discussions. There was a book that was written recently as well by a law professor named Steve Vladeck called The Shadow Docket, focusing on how the Supreme Court has increasingly been issuing decisions in these kind of shadow unsigned rulings where they don't even explain why they're reaching the result that they actually do. Congress could require the court to hand down written explanations for all of their decisions, get the justices back on kind of focusing on the day-to-day work of judging and less on these hot-button political disputes. But ultimately, I think a lot of the momentum is going to have to come from within the court itself. It's going to be on the justices themselves to take responsibility for their own behavior, to ensure that they are avoiding both impropriety and the appearance of impropriety in their activities. And I think the fact that the court voluntarily adopted a code of conduct back in November of 2023, and that all 9 justices were prepared to sign their names to it, suggests that, at least within the court, they are taking seriously the fact that these conversations are happening, the fact that trust in them as an institution is declining. they're taking seriously the fact that they're getting all of this negative attention as a result of the things that they are doing. And that at least inspires some confidence that, that things are starting to head in the right direction. I want to thank Justin and Adrian for sharing their thoughts with us this evening. And I want to give our audience members the opportunity to ask questions of tonight's panel. So if you would like to ask a question, please go ahead and come up to the microphone that we have at the front here and ask away.
Hello. Good afternoon, everyone.
Hi.
I am Kelly Gibbs, a junior.
Oh,
Oh, it's not on? Can't hear me?
That-
Oh, okay. I'm Kelly Gibbs, junior, major in political science. I have a couple of questions. So the first one was regarding transparency and how you're indicating that the public trust in the courts have declined since the 2000s. And if the public is requesting more transparency, my question or my argument would be how much transparency are we asking for that we don't want ourselves? At the same time that we are fighting for our own type of privacies and things of that nature and not being highly polarized with social media and things of that nature where sometimes we want the privacy of our own, then how can we at the same time say, I want to see everything with the justices, but I don't want you to have the same transparency that I have in my home? I think there should be a boundary and a balance between what we're asking for and what we're really wanting. If we're looking for transparency, it should have to be on both ends. The second thing that I wanted to bring to the attention is about the ethical actions of the justices and how that coincides with their families and like their children or friends. Like you mentioned for Alito, his wife was the one that did the indications of with the flag and going back and forth with the neighbor. So at what point do we say, okay, well, the justice, you're responsible for your entire family and children and friends versus, okay, if we haven't seen you do this physical action, then how can we hold you accountable for everyone in the household that has free will to make their own decisions at the same time? Thank you.
Great questions. So I'll take a stab at the first question about transparency. When I hear the word transparency, I'm thinking more transparency about the process and the shadow docket that Nick was talking about, where the public gets to see more of the business workings of the Supreme Court. I'm not talking about their private lives, where I don't want them to be, desperately do not want them on Twitter or TikTok or something like that, right? Tweeting all their thoughts. They should have privacy in their personal life in the same way, though, that a public figure surrenders some of their privacy by virtue of what they have chosen to be. A movie star, unfortunately, is going to get hounded by paparazzi. I don't like that, but they are famous, and it just happens. And I think a Supreme Court justice has to understand that by taking the very top, best lawyer job in the whole country comes with a consequence that you are going to be more under the public eye, and you will be subject to more scrutiny, and may be held accountable, fair or not, for what those closest to you are doing. And everyone, they have a right to their own freedoms. They are still free people, and their spouses and children are free people, but it does reflect on them sometimes.
no, I agree with everything that Justin said there. And I think when we talk about transparency on the court, we're certainly respecting the privacy of the justices in their own lives and with their own families. And I would even go further and say that the privacy of the internal deliberations of the justices, that for the court to be a functioning institution, the justices need to be able to have a free and fair and frank and open exchange of views amongst each other. They need to be able to deliberate within their own kind of private conference about the cases and not have to worry that a few months down the road, the New York Times is going to be reporting on the kind of intimate details of everything that went on behind the scenes in the court. I do think it's bad for the court as an institution for it to kind of lose some of that luster, that kind of ivory tower bastion of justice that had led to it being more respected in the past. Where transparency is important, I think, is that when the justices make rulings, when they make decisions that affect people's lives, that affect public policy fundamentally, they should explain the reasons for those decisions. And so it's particularly, going back to the shadow docket, when the justices simply release a one-sentence order that resolves a major question of law or public policy with no explanation.
Or allow someone to be killed.
Right, or as has happened frequently, denying a clemency position from a death row inmate who has raised serious questions about the process that led to their conviction or about the method of execution that the state's employing. When the justices just kind of swipe those away without even explaining their reasoning, I think that undermines justice. I think that undermines public trust in the institution. So there's a balance that we can strike that allows the justices to protect their personal privacy and also their deliberative privacy within the institution, but which requires them to explain and give legal reasons for the outcomes that they are reaching that profoundly affect so many people's lives. And to the second question that you asked, I do think that it is somewhat unfair the degree to which, in particular, Justices Alito and Thomas have been kind of unfairly portrayed as biased or as prejudging cases by virtue of the activities of their spouses. I think that there are rules in the Code of Conduct that deal with and provide for some circumstances where the activities of a family member, particularly when there's a direct financial benefit, should force a justice to recuse themselves. But I don't think that the wife of a Supreme Court justice flying a flag or the wife of a Supreme Court justice being politically involved is something that we need to be as outraged as, for instance, a justice getting hundreds of thousands of dollars in gifts from a rich benefactor. I think those are very different things, and they should probably be treated as different things.
When you all spoke about recusals, you stipulated the point that one recusal could potentially lead to a split vote. And while I understand that balancing the stakes is not only extremely important, but the job of the Supreme Court justices, I had the question, in the case of these recusals, should justices be compromising the integrity of their vote for the potential fear that it may cause a vote split?
Great question. Thank you for wearing an ethics shirt. I know that you're invested in the process. Are you on the ethics team? The ethics bowl team?
Yes.
Okay, good. Because that's one I would want to be a judge for, is to hear you debate that. Gosh, so ultimately, I think that morally it would be best if they recuse themselves, consequences be damned, even if it's going to be a split vote. But pragmatically, I don't know that's always the best solution. So my idealist would say that's the best choice, but I don't know how that falls out in real life.
I mean, procedurally, morally, yes, right? Like recuse, if there is no way that you can be unbiased in a case or maintain the perception of that, fine, recuse. The procedural mechanism for that is perhaps letting whatever harm is coming to the court continue for more years while another case develops to test the very same thing. And so at that point, you might just be ethically in a balancing, right, situation of greater harms. And I think that probably, I'd like to say that maybe weighs on some justices when they're weighing recusal, especially in cases that have, constitutional rights import to them.
And sometimes agencies will let bad stuff happen, and then they'll wave the flag and be like, Congress, we need your help, fix this. This is a problem that you've caused. Please do something. And so if enough bad stuff happened because of a setup of recusals, it could prompt Congress to come up with some other solution.
Yeah, and if you read the recusal section of the new code of conduct for the justices, it does talk about a lot of these things. It says that the default position is that justices should participate in cases unless there's a particular reason not to. But it also talks about something called the rule of necessity, which is not a new invention. It's something that goes kind of way back in Supreme Court tradition. But you need 6 justices to sit in a case in order to have a quorum to issue a decision. And it can be a profound injustice if recusal forces the court to not be able to issue a ruling. It can lead to federal law, the Constitution meaning different things in different parts of the country. Yeah, so I think there is a balance there, but the court's own kind of internal procedures attempt to strike that balance and attempt to sort of specify what the conditions are where for kind of the standard idea of having to recuse, when that should be overridden in the interests of justice and legal process.
All right, there was a gentleman after you that wants to speak. Please ask an easier question.
Good evening. My name is John Johnson. I'm a pre-law student here. Oh, a little louder for you? Yeah. I'll do you one. My name is John Johnson. I'm a pre-law student here at UNF, dual majoring in English and in philosophy with a concentration in law, politics, and ethics, and then dual minoring in communication studies and film. I'm very interested in this current narrative that we have throughout American politics that seems to stem from these elements of ageism that has now permeated itself into the way we see term limits within our electorate and within our leaders, right? There are several high-profile political leaders in recent history: Dianne Feinstein, Mitch McConnell, Joe Biden, Donald Trump, to name a few, even Nancy Pelosi, where significant questions have been asked about the age of these individuals and the power that they wield in connection to their political stances. It's often seen that those who are of a more conservative background might draw that particular background and those political stances from the lives that they lived as older individuals and the perspectives that they had growing up. So I'm wondering about your feeling about term limits, which we discussed previously, but specifically relevant to the point of age. Because one of the most common counterpoints that you hear is, with age brings wisdom. Don't you want that qualified and experienced Supreme Court justice or president who has 40 years of experience in politics because they know how to navigate in such a way that is substantially better than individuals who might have 5 or 10 years of experience? But it is still a question to be asked, given the overwhelming majority of the taxpayers and the average age of the American who is actually contributing to our economy and participating in our political process is within the ages of 25 to maybe 45, when our elected leaders are substantially older than that. So I was wondering if anyone had an opinion specifically relevant to those factors. Because if you go back to someone like Ruth Bader Ginsburg, who was very, very old at the time of her death, we still wonder about the health complications and how those things might interrupt the cognitive processes of these individuals who have to make such substantial decisions within the political dynamic of our society.
So this has been an issue that has caused problems on the court before. Fortunately, not for quite a number of decades, but back in the 1970s, Justice Hugo Black suffered a stroke and did not want to resign from the court because he did not want Richard Nixon to appoint his replacement. Similarly, Justice William O. Douglas, who I mentioned earlier, continued on the court well after his mental faculties had begun to taper off. And ultimately, in those situations, the pressure to step down has come from within the court itself. It's come from the fellow justices. This is part of the idea that I talked about at the beginning, that other than impeaching a justice, there's really not anything else that you can do external to the court to get them out of those positions. On your point about the age of justices, I certainly do think that if term limits were possible, this would be a way to solve this problem. It's also the case that because we don't have term limits, there's actually been incentives for presidents to appoint younger nominees to the court, particularly in the last few decades. And you have to strike a balance. Justin talked earlier about how this is the top job for a lawyer in the entire United States. So to be qualified to be a Supreme Court justice, you have to have put together a pretty significant record of experience and achievement. But if you look at recent justices, these have been individuals who have been appointed to the bench at around about kind of 45 to 50, substantially younger than any presidential candidates we have in recent years. Let's just say that.
I actually, even though I posited the idea of term limits, I actually don't tie that to age. I wouldn't have a maximum retirement, like a retirement age is mandatory or a qualification that you must be so young. We have a very fast, theoretically moving branch of government, the legislature, where you vote in people very regularly and they should make laws that respond to current feelings. And so if you have a fast moving branch, it actually, for the sake of balance, it's good to have a slower, more traditional, rooted in the past branch, just to keep the country from spiraling out too quick. So I actually think it's good to have well-experienced, maybe people who are from a prior generation, moderating that swing a little bit. So I would just clarify that on my thought.
Yeah, I wouldn't want to draw an age line as well. Although I will have to say, if you look at state judiciaries, a lot of states have mandatory retirement ages for judges. Not a choice we have with life tenure on the federal bench. The profession says that we're supposed to still be able to make ourselves competent to do our job and that we are the best judges of when we can no longer do that. And that is the same kind of professional status that is supposed to govern folks on the bench. As Nick mentioned, internal pressure usually takes care of that. But we have a situation now where there has been quite the tussle over a federal judge on the lower bench that won't resign in her 90s. And there's some issue with how that court is being handled. Yeah, I was going to say that the ultimate spoiler to that was good news. We are now nominating folks who are just about 45 to 52 now, and they're staying on the bench for a really long time. And instead of it being legal experience prior that qualifies you to the Supreme Court, it's often the right political connections to get the nomination with a stellar resume. And that stellar resume tends to look quite alike if you kind of look at who actually gets on the Supreme Court, but nominated earlier so that they can sit on the bench for a really long time, and their experience comes from being a justice, basically.
So you talked about the appointment of the 18 years with each president having 2 appointments. My question would be, how might a system of appointing a new Supreme Court justice every 2 years with an 18-year term impact the balance of power among the branches of the government, particularly if one political party controls the presidency for an extended period of time?
That's a great question. You've just poked the hole in my whole idea. It won't work anymore. I don't know, Nick, Adriana, what do you think?
I mean, you'd end up most likely, if you had one party control of the presidency, and I assume that you're having the Senate in there for quite a long time too, so that your nominees are actually getting confirmed. And then you kind of stack the Supreme Court. It would be hard to hold it long enough to get something more than 6-3, right? Which is what we have now. General political trends don't follow that, but in the theoretical sense that you had this kind of dominant one-party control for a while, I mean, I guess what you'd see is a Supreme Court that perhaps doesn't check, especially the executive, as much. So you might see either a big swing in deregulation or a high regulation period. You might let the executive branch do more. Maybe you have a Congress that does less and the courts do more, or maybe Congress shows up and starts doing things. I think the interesting question there would be how that might affect all of the cases coming out of the states, and really aggressive cases that the Supreme Court has been increasingly taken without full appellate review. And that's part of, managing their docket in ways that Nick talked about as well. It's an interesting question. There are certainly that this cycle won't fix everything theoretically, but it is kind of based on looking at general trends of how power is held. And we don't have that kind of consolidated power, many trends of that consolidated power in the modern era.
Yeah, I don't think term limits and having seats that become vacant and allow presidents to appoint new justices on a regular calendar kind of solves the problem of the Supreme Court potentially becoming ideologically imbalanced. What it does solve, I think, is the problem of the court becoming ideologically imbalanced just by sheer random luck of the draw. So if you look back since 2008, Democrats have, by the conclusion of Joe Biden's term, will have held the White House for 12 years. Republicans will have held it for 4 years. And both parties have appointed 3 new justices in that time. So Democrats have had 3 times as much time holding the White House, and the balance of power on the court hasn't changed. We saw in one 4-year term, 3 appointments by President Trump that dramatically shifted the ideological alignment of the court. None of the Democratic appointees in that 16-year period have shifted the overall ideological alignment. And that is pretty much entirely random, possibly one. So what it does, I think, ensure is that if a party is going to have a long-term impact on the court that genuinely shifts its ideological direction under a term limit system, it has to be because that party has enjoyed significant and consistent public and political support at the ballot box over a longer period of time, and not just because that party happened to control the White House when a few vacancies occurred that shifted the balance.
We're setting up an interesting problem with a lot of nominees quickly that are around this very young age when they're nominated too. That if you kind of look at the median age of the court, we're going to have serial vacancies are going to be a thing where we have not just, one justice that might strategically retire or might be very old or might want to leave the bench or might die on the bench. We might have groupings, right, of a couple.
John, are we at time?
Yeah.
Are they going to kick us out of this room?
We probably have time for maybe one more question if anyone wants to ask one, and then we should probably wrap up. Or 2.
My question mainly piggybacks off of what you all said at the very beginning, talking about rulings affecting pre-existing rulings that you mentioned. We all are familiar with overturning of Roe v. Wade, but the most recent one that happened back in June with the overturning of, make sure I'm having this correctly, with the Lubribright Enterprises v. Raimondo with the Chevron doctrine. There are thousands of cases that cross-reference that for federal regulations. With that, I was having the main question of what are your thoughts on having rulings that are existing for 40 plus years that have been pretty much anchored into the legal system, suddenly changing, having to nearly completely rewrite how thousands of documents are going to be interpreted under the law?
That is a huge pain because I should say that there's a natural evolution to the law. The rule of law that we have now is very different than the rule of law we had 300 years ago in the common law that came over from England. Things have just changed. And it's okay to have change. And it's okay for that change to fundamentally change the way the law used to work, because that's happened and been expected. But when it happens a lot really fast, that's sort of a problem. And so what's happening right now that's causing a decrease in trust is that major fundamental pillars of the law that we are used to are all falling at the same time as opposed to incrementally. So the case that you talked about that overruled Chevron, just for the benefit of you all who may not be familiar, we have three branches of government. The executive branch runs agencies oftentimes, and those agencies come up with rules. Congress passes a law that says it's okay to tax people, okay? And then the IRS comes up with all these like nitty-gritty rules on how the taxation works. What the Supreme Court has done is now called into question every single regulation that every single agency makes. So in my very practical work, I deal with Title IX, which is the rule about discrimination on the basis of gender and sex. And the federal agency, the Department of Education, is trying to change the rules for how that works, and they came out with something. But as soon as they came out with it, it got stopped by all these courts saying these rules aren't worth, we don't have to give deference to you. So now it's kind of unclear what rule is best or what rule we should follow for purposes of preventing discrimination and sexual harassment on campuses. So it's that kind of like practical ambiguity that happens when you rip away precedent that's been there for a long time, especially in a government where we have such a regulatory state.
I'll also say that, especially on this issue, right? So with the overturning of Chevron and the Loper Bright, Corner Post, and Relentless, the kind of three cases that really open up this door to challenge regulation, looking at what the court is doing is what kind of everybody's doing. They're looking for what cases the court's going to take and what challenges are coming and the instability of law that things that might be enjoined earlier. But an interesting thing that I think isn't getting as much traction in the media is what the court is not doing. So there are a lot of cases right now, especially in an environmental law, that are based on exactly what you've talked about, that the court is just kind of relisting consistently, meaning they're supposed to address them in conference and they're just kind of like, let's do that next conference, let's do that next conference, let's do that next conference. And some of that is they might be trying not to take a controversial docket before an election. Some of that might be that they themselves haven't really figured out where this is going to go or the kinds of cases they want to shape this law going forward. And so there's just this kind of mass of petitions sitting there that they're not kind of getting through and addressing in a way. And it's a very, because it's not one of those kind of really transparent parts, it's one of these kind of geeky, nitpicky things that there's actually a blog where someone keeps up with relists every week. When I say that we should be more knowledgeable about how the court works so that we can see these kind of big shifts, maybe right before they happen and not just when those cases come out, this would be one of them where I'd be looking.
Well, I don't have anything to add to those great answers, but final question, and then I'm afraid we will have to wrap things up before they come in and kick us out of the room.
Okay. I think this is good. Okay, so hello, I am Beth Lee Laktama. I am a senior at UNF studying political science and English, so double major. And my question is regarding the questions surrounding cannabis or marijuana. So we know currently on the November upcoming election, we have as Floridians to decide whether or not we want to legalize marijuana in our state. But relating this back to like our discussion tonight, I want to ask if you guys have any insights on whether or not this will be something that the Supreme Court takes up. Because I know different states are kind of figuring out whether or not they want to legalize it or if it's criminalized still. So I just wanted to ask a question regarding that.
I think they're going to ignore it for as long as they can and hope that Congress does something or that there's federal, deregulation.
Yeah, so to answer your question, it's so interesting because many states have legalized marijuana, but the federal government still says it's illegal. So there is a really good argument that the federal law overrides that, but the feds don't want to get crosswise with popular opinion either. And so just like Adrian said, the Supreme Court is also sensitive to public will. So if you look at their jurisprudence around LGBTQ rights, there was a lot of stalling and taking baby steps until enough public consensus in the country came together where it was clear that most people supported LGBTQ rights. And at that point, and only then, did the Supreme Court step in and issue a ruling that's saying, for example, in employment, that you can't discriminate on the basis of sexual orientation or gender identity or transgender status. So the Supreme Court is wise in its reading of the room. And so I agree with Adrian that they're probably not going to step in on marijuana until it's very clear that everybody wants it. And in the meantime, we'll be in this odd situation where the states say it's legal and the federal government says it's not, and I just hope that there's no prosecution.
And the Supreme Court really likes polling jurisdictions too. So it's probably looking for these kind of state dominoes. And when there are enough states on the map, right, then they'll be like, well, especially with a conservative-led Supreme Court, they can say, well, states have made these decisions for themselves, so we'll just nationalize it at this point, right?
The court actually had an opportunity to kind of wade into this debate a number of years ago after, I believe it was Colorado, passed or legalized recreational marijuana. And there was attempts by a couple of neighboring states, Nebraska, I believe was one of them, to sue the state of Colorado, basically saying that you're allowing something that's illegal under federal law, and this is kind of creating a public nuisance, and pointing specifically to the possibility of intoxicated drivers kind of leaving Colorado and potentially causing hazards in neighboring states. And I don't believe there was a single justice who voted to even hear that case, let alone issue a ruling. But as Justin said, right now all of these states are relying on the fact that the federal government could crack down on both medical and recreational marijuana usage in states that have chosen to do so. The federal government could shut the entire industry down if it wanted to. But recent administrations have not been willing to do that, I think, as Justin correctly diagnoses, because it would be an extraordinarily unpopular thing for the federal government to do. But that conflict between federal law criminalizing marijuana and state law legalizing it, that remains. And it's really only the enforcement discretion of the federal government or lack of enforcement that has kind of allowed those states to pursue a very different policy direction.
Thank you. Great question.
Sorry, I was just talking about banking.
Yes, it does.
Mm-hmm. Okay, well, we are out of time. I would like to thank everyone for coming out. Please do take a look at the other Ethics Week events that are going on and try to attend those as well. And make sure, if you got a ticket for your Ethics Week t-shirt, make sure that you cash that in and get your swag. Thank you, everyone.